Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Canoni, Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
The jury has questions. They're all of us.
You can learn so much information from juror questions.
I have questions. The jury has questions. We have questions.
I love juror questions. I love more information.
Let's talk about these questions, guys. Let's talk about these questions.
So let's hear what those questions are.
What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.?
When was Karen Reed driving drunk? At 12:45 or 5 a.m.? How could she be driving at 12:45? Right? Don't we have voicemails and connecting to Wi-Fi and being in John's house? That's the evidence that was presented to this jury. Now, if it's 5 a.m. and she's out driving again, then I can see how the jury's getting there.
They don't know what she did when she went back home. She's pissed off. She easily could have poured a big-ass bottle or a big-ass glass of vodka.
They think about 12:45. How is it possibly guilty? Because I was not driving at 12:45. So that should be not guilty. Easy. What's question number 2?
The second, are video clips of Karen's interviews evidence? How can we consider them?
It's not as good, right? Because we know the defense did not play any clips to add context. So any of the clips they're talking about are from the Commonwealth's case.
Because she talked pretty heavily about how much she was drinking.
Maybe some people are really hanging their hat on Karen saying, oh, I had, the drink count was 4, 5, 6 drinks. I don't know.
She admitted in one clip that she had 4 drinks. She admitted in another clip that she had, I don't remember, maybe one clip said she had 9 drinks.
In conjunction with the OUI questions, we know she said some things about drinking and driving.
She said something along the lines of like, I, obviously wasn't as safe as if I hadn't been drinking at all, but I felt fine.
If the jury's really focusing on her statements in conjunction with the OUI, does that make them lean more toward guilty of OUI potentially?
Seems like that would be what they're talking about because that's relevant to the OUI.
And the third, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge?
And that, folks, is the big question. What does that tell you? Well, that tells you they're confused with the count 2 verdict form.
The jury is stuck on the OUI charge, and they want to know, if we convict her of just OUI, does that mean that you are going to convict her or charge her with or sentence her to a manslaughter charge?
The jury asked, if we convict on the 5th one, which is the OUI, if we convict on that one, it doesn't convict these other ones, right?
It could be understood if you're checking box 5 because the top of the sheet says, it says literally at the top of the sheet, count 2, manslaughter DUI, right?
Does voting guilty, for example, on the 5th lesser included, which is OUI, does that create a scenario where she's guilty of the entire count 2 charge?
And so it's like, oh, if we find number 5 by itself, we're finding manslaughter DUI. They're not, but of course, that maybe isn't necessarily clear to them.
Because there's nowhere to say not guilty on each of those above it.
They're confused that if they check guilty here, there's nowhere for them to check not guilty for the first 4.
Which, fair enough, right? It's like, are we finding her guilty of manslaughter?
So do they think a guilty here means guilty all the way up the board?
The answer is no. You're finding her guilty of just straight, no nonsense, no complication, straight, normal, uncomplicated DUI.
Do you think the defense is like, we fucking said about the jury form. We've said it.
Everything that they asked about is pointing directly towards that OUI charge and that OUI charge alone.
Right.
The defense has to be thrilled with these questions.
Yes, very clear. All we are talking about is the OUI. We are having no conversation whatsoever about homicide.
That's huge. That's huge.
The first question, the time of the OUI. Any suggestions?
Your Honor, do you want to hear from the defense first?
I'll hear from you're standing up, so I'll hear from you first.
I'll hear from whoever.
Question number one, what is the time
No
frame
control.
for the OUI charge? Offense 002, section 5, OUI at 12:45 or OUI at 5 a.m.? Our suggestion would be something along the lines of, ladies and gentlemen of the jury, you have the evidence. It's your decision.
You are the fact finder.
You're the fact finder.
Finishing each other's sentences, some would say.
My suggestion would be 12:45.
He wants a hung jury.
I have the indictment. I'm looking at it. It only says the date.
Unless they said at or before, at or upon 12:45 a.m. on this date.
If it's not in the indictment, I'm uncomfortable telling them a time.
Ding, ding, ding.
It's because nobody was planning on OUI.
It's because they didn't charge her with a DUI. They charged the manslaughter and they charged the date. That's all they can give them.
Are the video clips Karen's interviews evidence? How can we consider them? So I'll tell you what I was planning on saying, then you can add to it.
Respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate. If any.
Okay.
Thank you.
And she has no problem with that. He agrees with what she was going to instruct. Give them whatever evidence, whatever weight you seem necessary. He said, if any. She's like, sure, that makes sense. If any.
Whatever weight, if any. Got to have that if any in there.
Fine.
If any. Yes, if any.
We know all the jokes about if any, and in this case.
Jackson is full-throatedly in there going, what if any? Give it what if any weight.
And she's in lockstep. Once again, judge seemingly agreeing with Jackson. But does Hank Brennan agree?
Hank begging for a mistrial. Son of a bitch.
It is better because they don't have to give it any weight. They can say, I don't trust it. They can say it was taken out of context. They can say it's not sworn.
Oh, yeah, the prosecution's not going to be happy with these questions. They know exactly what this means.
It's over, Hank. Just tuck your tail and go.
They can have any reason for saying, I don't think this evidence matters.
Cammie wants her tax money back.
Yeah.
Brennan is not going to be happy with any of these questions.
Give them all, just like you said. Do exactly what you said and add if any.
So what I'm going to say is, yes, the videos are evidence. You should weigh the defendant's statements as you would any other piece of evidence and give them whatever weight you deem appropriate.
I don't have a principled objection to it if the court adds the word if any.
I understand.
Because every single.
She's like, I understand, and I'm not going to.
Because
And
every
she's not
single.
going to do it.
I don't want them to
understand. I'm
think,
not gonna
for
say
instance, the way that it's worded as the Commonwealth suggested it.
But I understand.
They have to weigh it the same way they weigh other pieces of evidence.
So she basically, I thought she was going to do a little combination. It was vast majority of what Hank Brennan wanted. And his rights are protected.
Okay, your objection is noted. Your rights are safe for appeal, but no, I'm not going to say if any. Meanwhile, Lally said it, if any, during the first trial 7 million times.
Third one.
And now we get to the big one. This is the big one.
What do you want to say, Mr. Jackson?
No.
Your Honor, I appreciate the effort that the court went to amend the
What we told
verdict
you
slip.
so.
Quote, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge?
The answer is no.
The answer is no. I think question number 3 is answered by the amendments in the verdict slip. So we certainly could.
So they have an amended verdict slip. Mr. Jackson thinks it answers most of their questions. We'll listen to a little bit of their back and forth, but we're going to come back when the jury comes in to hear exactly how Judge Cannoni reads it to the jury.
Okay.
We had the same suggestion. It appears that the court is not inclined to give it. If guilty, check one or both of the following. And there's a typo. It says the parenthetical
We
says
fixed it.
check one of.
Yes, so we
fixed
fixed
it.
We changed of to or.
That's
We're going to just skip ahead. We'll hear what Hank Brennan says a little bit, but we're going to get all the answers when she actually reads it to the jury to see, is it less confusing?
I don't have any disagreement with the
Good.
minutes.
Okay.
Something I wouldn't have an objection to, but I think the form that you filled it out.
Brennan, I'm going to try to gain him up a little bit. When you said you have no objection, that's when you sit down. It's okay to just sit down.
So here comes the jury. Back in. Here are the actual answers Judge Cannoni gives them. And this is what they're walking back into the jury room with. And this is what they're going to go and continue to deliberate.
I'm not sure of the exact language I can use. I don't think that's necessary.
Sigh, she doesn't want to do it. Just let them know. Do you want them to come to a verdict, assholes?
insufficient for them.
No, he doesn't.
What do you think about the defendant's position that
The first one. Stop here and sign. You're done.
so for the third question,
So now the third question. The first two are kind of simple. The if any would have been nice, not that big of a deal, I don't think.
They would feel better if they could write not guilty somewhere. Just they would feel better about it.
Would have been better if she said no, right?
Right? Because the top line says, you know, manslaughter while DUI.
If we find her guilty of OUI, is she guilty of the whole count too? It would have been better if Judge Cannoni would have just clearly said no.
with the blood alcohol level of 0.08 or greater.
They want to be
If you find the
sure.
defendant guilty of operating a motor vehicle under the influence of liquor,
Sign
then
it.
stop.
And stop.
So you don't go down to OUI unless you find them not guilty of the higher charges.
We received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge?
Okay, so Solomon, the question was, if we have a verdict on 2 of the charges and we're hung on 1 of the charges, what are we supposed to do? Is that a hung jury for all the charges? This is exactly the situation that the first jury found themselves in.
I think what they're saying is we're fucking hung on the OUI.
This is so crazy. It's almost like they literally watched everybody talk about the case. This was the question the last jury did not ask. But once again, those 2 charges should not have even ever been here. The last jury did the same thing. That's crazy.
They're hung on maybe DUI, and therefore they're hung on charge 2, but they have a verdict on charge 1 and charge 3.
It's a theoretical question, and we don't answer theoretical questions. I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
No, you need to tell the jury if you have rendered verdicts, then you need to fill out those verdicts. Given that that came back before the other questions.
So this question of if we just hang on count 2 and we're not guilty on 1 and 3, is it hung on all counts?
Then I think we should ask if this question has been resolved. You heard what Jackson said. That changes literally everything.
I think she should give them some instruction. I really do, that so they know that that each case is individual and they're to make a decision on each count.
We're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps.
Doesn't she say, and they vote? First step down the wrong path is to say, throw our hands up and say, well, we can't answer that question. Well, we know we can answer.
So I don't know if I want to put you in an uncomfortable position. Ms. Giannetti, I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel, Joe?
1 minute.
How about 1 minute? You guys are 10 minutes late.
We just need 1 minute. Thank you.
1 minute. Oh my Lord.
I mean, that's so annoying that she wouldn't give them 2 minutes. Like, what kind of joke is that?
And she's giving them half the time because you are late.
2 minutes for criminal defense attorney team to confer with counsel, and she's like, you can have 1 minute.
You know you can't have 2. You can only have 1. Oh, for heaven's sake.
What world are we living in? Like, I don't know. Could you imagine that, Dad? Like, asking for 2 minutes and the judge saying, no, you can only have 1? Like, that's crazy.
She's late every day. Get days off.
She's got to show she's in control. So even if it means that she cuts them 1 minute, it shows, look, I'm the boss and you're not going to tell me what to do.
Jesus. So you guys know what happened the first time, right?
This is exactly the situation that the first jury found themselves in.
Well. They don't know whether she's DUI or not. Good Lord.
Like, it's so clear. If you take all 4 questions in context, they're not guilty on 1 and 3, and they're hung right now or arguing about OUI.
There's people that are willing to hang the jury over DUI. Is pretty much what it sounds like.
I mean, that's what everything is pointing to. We don't know that to be a fact.
They're hung on maybe DUI, and therefore they're hung on charge 2, but they have a verdict on charge 1 and charge 3.
We don't know that to be true, but that's what everything is pointing to. So why take the tools out of their hands to give a verdict? I don't understand that.
I don't either.
Almost like they would like some kind of guarantee about how this is supposed to go down.
This whole trial is about the jury. So why wouldn't you answer their questions?
But the part that's confusing is, I mean, is this what we're doing over a misdemeanor OUI count? Are we now literally potentially blowing this whole thing up because of these confused jury instructions, and it's happening again?
So predictable. This is pathetic. This is not court. This is a circus.
I hate everything.
The reasons
about
I
this right
stated
now.
is theoretical, and we tell jurors that they cannot be concerned with the consequences of their verdict.
So the jury just wants to know, what can we do? If we are hung on charge 2, does that mean that we're hung on the entire verdict? And Judge Cannoni wants to answer, I can't answer that for you.
The court answered the question as you suggested just now in open court. It's premature to address this question at this time.
No, what do you say, Mr. Brennan?
Yeah, he wishes she would say that it's premature to answer that, meaning ask it again later.
What's the Commonwealth's position on the proposed?
I agree with your first suggestion.
Yeah, I'm going to send it in like this. Your objection's noted.
Oh my God.
Make my record a little bit clearer. Simply indicate this is not appropriate for me to address at this time. That assuages all concerns. Certainly assuages our concerns and it protects Ms. Reed's rights. I think that.
Well, I think what I could add is this is a theoretical question, not a question I can answer.
Take it.
The same. Is there an objection?
Yes.
I understand, Mr. Jackson.
Take the theoretical question. Take it.
Is there an objection to me putting this is a theoretical question?
Take it.
Not a question I can answer.
At this time. She's not going to say at this time.
And she really pisses me off. Like I don't get what she's doing.
Okay.
This way it does.
Okay, it was a clear question that the defense first told me to ignore. So
I didn't
is that.
Oh, God.
All right, we are all set. So let's send this.
We are all set.
That mode, she's doing it.
All set.
She doesn't want to deal with it, and
She just had to get that little swipe in there. It's a clear question you didn't even want me to answer.
So I'm not even sure if they're being told this is a theoretical question or not at this point. I don't even know if she added that or not. I don't even know what's going on, man.
Terrible. Just terrible.
She is such a shithead.
All right, Bob, why
not like
are
that.
you why is this causing you so much concern?
Everybody breathe.